I'm going to call the meeting to order for Thursday, May 28, 2015. I love reading my title here that your training gave me, the Anchorage Assembly Committee on Regulating and Taxing the Cultivation, Manufacture, and Commercial Sale of Marijuana in Anchorage. And by the time I read the name, we're run out of time for the meeting. Let's begin by going around and doing introductions. Ms. Stimbowski is joining us. We'll start with you, Erica.
Erica McConnell from the Planning Department.
I'm Dan Moore, City Treasurer.
Bruce Schulte, I'm a guest on the board with the Coalition for Responsible Cannabis Legislation.
Dick Train, Anchorage Assembly.
Pete Peterson, Anchorage Assembly.
Bernie Hall.
And
Ms. Franklin is in the building. She's probably trying to find the right room. My guess is she went, there she is.
Sorry about
I
that.
figured you might have gone to the 8th floor first.
Yeah.
Come and join us over here.
Thanks. Hi, Bruce.
Good looking for where you're going to sit. They want to have the microphone right next to you.
Thank you.
There you go.
No I see how it
No
is.
F-bombs.
Yes, ma'am. I
We
promise.
have a scrambler that can kill that if you wanted to hit it.
Miss Franklin and Mr. Moore are going to be our two stars today. As a committee, we're rather excited. At our last meeting, we really didn't know where we were headed, and we made specific direction on where we were going to go because of the fact that you hadn't really been able to engage at that point in time. But shortly following that meeting, the Marijuana Control Board was established. The governor signed it into law. Ms. Franklin had already began shortly after that in working with the current Alcohol Control Board to begin the drafting of regulations. So what we're all excited to hear from is from you, Ms. Franklin. We're going to just let you have the floor and kind of bring us up to speed on what's happening and where you're going to take us.
Okay. Well, first of all, we had a meeting on April 30th with the Alcoholic Beverage Control Board. That may or may not be the last meeting of the ABC on marijuana. It really depends on how quickly the governor's Office of Boards and Commissions is able to get the Marijuana Control Board put together. We have a meeting set for July 2nd in Fairbanks, and that is going to be either the Marijuana Control Board's first meeting, or it will be, hopefully, the last meeting of the Alcoholic Beverage Control Board on marijuana issues. And at the April 30th meeting, we introduced our first set of regulations in a draft form, which the ABC board looked at and approved to release and open a file with the Department of Law to open a regulations packet for that set and to release those for public comment. So those went up for public comment on May 19th, and the closure of the public comment period is June 20th. We will answer questions on our website that are received by June 10th. So if someone from the public has a question rather than a comment, but all of the comments and questions need to be in writing, and the instructions for that are both on our website and in the online public notification system. So what we rolled out at that board meeting was kind of a snapshot of how we're going to accomplish getting all these regulations in place by November 24th. And we're going to do it in a wave of 3 sets of regulations. Each set of regulations will have either 2 or 3 board meetings. And set 1, it's possible that we would only have 2 board meetings on this set, but sets 2 and 3 will have 3 board meetings for each set. So the first board meeting is an introduction of this set of regulations, and then an indication and a vote by the board, the Marijuana Control Board, hopefully from this point forward, of whether they want to release that draft set to the public and open a file. And then we open a file with the Department of Law. We put those up for public comment, and there's at least a 30-day period for public comment on those regulations. And then we bring those comments back to the board at board meeting number 2 on that set, and then the board looks at that and looks at whether or not there are any recommended changes to the regulations based on that set, whether the board itself has recommended changes to the words on the paper based on the public input. And then there's a 3rd meeting set for the board to vote on whether or not to adopt that set of regulations. So we're going to have 5 board meetings between now and November 19th, and we're going to waive those 3 sets of regulations through those 5 board meetings, so that hopefully each set gets 3 board meetings. And there's just a tiny asterisk next to that, because this first set, which was a kind of an abbreviated set, it really only contained 2 major sets of rules. And this first set, it's possible that the Department of Law might recommend, if there are draft changes to this set, that and the ABC board ends up meeting on it on July 2nd versus the Marijuana Control Board, that they finish up this set, if that makes sense. And so we're still debating that internally with the Department of Law. So set 1 might only have 2 board meetings. The other 2 sets will have those 3 board meetings to really vet those out through the public process. And we're really trying to encourage members of the public to send as many comments in as they wish, because I think it's really going to be important for the state legislature when they get back in session in January if we have regulations that have been adopted by the Marijuana Control Board, that the legislators be able to see the public's investment in that process. And so this is a process that's much more luxurious than the process the legislature has, where sometimes they're introducing a bill and doing amendments later that day, and things move very, very quickly down there. It's very hard for the public to have input in that process. And this regulations making process is really designed to have a longer public input period and a real opportunity for members of the public and people affected by the regulations to comment on them. The set 1, which is now up for public comment, is the rules around local option. So there are really 2 local aspects that you might be interested in as a body to alcohol control, which we intend to bring over into marijuana control. One is local option, the ability of the local community to opt out, and then one is local control. And so what the municipality of Anchorage regularly engages in with regard to our liquor licenses is the local control aspect of liquor licensing, where the municipality has a right of protest, and the municipality has the ability to, and then we need the municipality to sign off on a license before that is issued. And a kind of a process for applying for licenses where an applicant would come to us, the state, and then come to the municipality, and then come back to the state. And this kind of handoff process through the 2 different governing bodies to end up at licensure. And so certainly when we look at the way the local control regulations are going to be written, which will either be in set 2 or set 3, we're looking at starting from a kind of a lovely mixture of what we have in Title IV and what we've learned both from Colorado and Washington. And we have an attorney who's very experienced in writing regulations, helping us with that job. So it's a very big job, but we think that we have a game plan, and we're going to be moving as we move through the summer and into the fall through those 3 sets of regulations. And our website is going to be a very important tool for everyone to keep apprised of where we are in the process. And the other thing that the new Marijuana Control Board will need to do when it's seated and at its first meeting is revisit the 1 regulation that the Alcoholic Beverage Control Board adopted as a permanent regulation relating to marijuana, which is that regulation that has the definition of the term public for purposes of 1738-040, the prohibition of consumption of marijuana in public. And so there was a lively discussion by the board around that at its board meeting on April 30th, and then the board voted to make that permanent. And the new Marijuana Control Board will need to revisit that because there's some transition language in HB 123, which is the bill that created the Marijuana Control Board, that they need to look at any regulation that the Alcoholic Beverage Control Board has adopted while they were waiting to get the Marijuana Control Board put together, and decide whether or not to adopt that as written, to amend it, or to reject it. And so that decision will have to be made as well. If a Marijuana Control Board is not up by July 2nd and is not ready to sit and look at set 1, and the Alcoholic Beverage Control Board ends up adopting set 1, then that same exercise, the Marijuana Control Board will engage in that same exercise with regard to this set of regulations. So it's really a kind of an intricately timed process of public input and board meeting throughout the next few months until we get all the rules around this new industry up. That's where we are.
Very good. Questions?
I'll start with some.
Okay.
I met with Ms. Franklin about a week ago. I believe we had a great meeting. And part of what I think would be nice to share with us is going to be that application process that is going to occur. And number one, also the fact that you shared with us that local option is going to mean that local municipalities determine the number of licenses that they're going to allow within their area.
Well, that, I wouldn't call that local option. So I try to keep these terms really separate so everybody
Okay.
understands. Because in Title IV, when you look, there's really two aspects to local control. One is local option, which is what's in Regulation Set 1. And that's just opting out. And there's a little menu there, you know. In other words, localities or local communities can decide we're opting out of sales but not out of grows, for instance. So we'll allow people to cultivate in this community, but we're not going to have any retail sales in this community. So there's a menu there that is sort of modeled after the menu that that communities have when it comes to opting out of alcohol, right? Mm-hmm. But that's a question of whether or not the community is going to participate, all right, and have that industry in their community. The local control aspect is for communities that are in, okay? So what you're talking about, Mr. Hall, is the numerical limit on the number of licenses within a municipality or a local government that is in 1738. So in the ballot measure that the people passed, the only place in the ballot measure that it talks about a limitation on the number of licenses is where there's some language in the statute that indicates that a municipality may numerically limit the number of licenses available. And so all of that, all of the rules around that are local control rules, and those are not in this set, okay? Right. Those are in Set 2 or Set 3. And those are certainly things that we're interested in everyone's input on. You know, if you have a particular input, I did indicate to you, as I have indicated from day one, that it is the management team at our agency, it is our opinion that the limited, when we look at other states who have limited licenses at the state level, the limited licenses have led to problems in those states that are similar to what we see with limited licenses on alcohol. We received a recommendation from the Alaska Municipal League, you know, regarding transferability of licenses. So you have two aspects to alcohol licensing that put quite a bit of pressure on those licenses and have led to some undesirable results in our state with regard to liquor licensing when they work in combination with each other. And that is a limitation of the licenses with the transferability. So the fact that there are only limited licenses available but that they can be sold means that in alcohol licensing, we have this kind of unnatural private market, secondary market value of alcohol licenses. That means that we as an agency spend quite a bit of time sort of guarding people's private property value in their liquor licenses. And it is our great desire that we not duplicate that set of problems in marijuana. And so given that, unlike in Title IV, where there's no language indicating that municipalities have the right to limit the number of liquor licenses other than through their zoning, you know, and other local control aspects that you have in Title IV, Title 1738, the ballot measure, definitely just says municipalities can limit the number of marijuana licenses. And so we've taken that and we're just working on these. We haven't put them out for public comment. They're not in Set 1. But in thinking about where licenses for marijuana establishments might be limited, it might make more sense for the localities to control those numbers than to put limitations at the state level. What we would like to see, that we know we want to see in liquor licensing, in marijuana licensing as opposed to liquor licensing, is to not have a situation where we have a lottery or something else that gets us into a situation where we have some minimum qualifications, and then we pick by chance who gets those licenses. Because what you end up with, and what other states have found, is that you end up sometimes with not your best operators licensed. And so we are leaning toward crafting a merit-based selection process that would enable the best qualified operators to hold the licenses and to not have limitations at the state level, given that the municipalities and local governments in 1738 definitely have the option statutorily to numerically limit the number of licenses that they want in their local jurisdiction. So that's kind of where we're headed with that, but that is not in this set that's
Right.
out. All you find in this set that's out is language and rules around how to opt out. Not on if you've decided as a local government, we're in. Okay, we're gonna have some kind of establishments. What are the rules around that? Those rules have yet to be written. Those are set 2 or set 3.
Very good. Let the record reflect, we've been joined by a representative from APD, and I'm sorry, I forgot your name.
Lieutenant Sean Case.
Mr. Training.
Ma'am, on 1738, I'd like our local, when we talk about local control, I want to make sure the city has the ability to control the amount of licenses they've got within their town. I know alcohol, for example, it was given how many portion amount of citizens. And I want to make sure we've got that option as a local government here to control the amount. Because we've also got community councils that need to weigh into this, decide if they want one in their neighborhood.
Well, there's a couple of things in that statute that give you that right. I mean, one is that certainly the statute indicates that there are going to be similar rules allowed around zoning and those types of things, which you use under Title IV to determine what parts of your city these establishments might operate in. But also, 1738 specifically gives municipalities the right to limit the number of licenses available. Now, how you do that is going to be up to your body rather than up to the Marijuana Control Board. So, once you decide as a body, okay, well, we want to set a limit on the number of licenses, then you're going to have to figure out what that limit looks like and who is selected. And what I can tell you, and what we know, is that every state that so far has issued marijuana licenses has been sued by the people who don't get them.
Yeah, well,
I mean, that just happens. We know that's going to happen, and everybody that's involved in this licensing process should know that that's going to happen. And so all we can do is do the best job possible to try to set up the fairest, most transparent licensing rules, so that, theoretically, anyone who doesn't get a license knows why they didn't get a license, so that charges of favoritism or cronyism or this kind of thing, that the rules, show that that's not what happened. That's about the best you can do, because anytime you have people who want something and they don't get what they want, our legal system says anybody can file a
All you
lawsuit.
gotta do is fair where the courthouse is.
Right.
Have taxi fare.
That's
Or
right.
Uber fare.
That's right.
Depends on what you want to use to get there.
That's right. So yes, I think that one of the hallmarks of Title IV and the way that alcohol liquor control works in the state of Alaska is to have maximum local governing body input, approval, and the local governing body being able to weigh in even on the continued operation of those licenses. So a local governing body not only has a right to protest a new license or a renewal of a license or a transfer of a license, but also has a right to protest the continued operation of the license if it's in that mid-2-year renewal cycle. And we have local governing bodies in Alaska that regularly exercise those rights of protest in the liquor side. So certainly with those, that is considered one of the strongest aspects of our liquor control scheme and is something that we want to bring over
Well,
into marijuana
You brought
control.
remarkable fresh air to the ABC board, because over the years, we'd protest something and nothing would happen. Now I'm seeing that being changed. Whether it's taxation or no matter what it is, you guys are taking a lot more interest in it. Hopefully you will with this board when it's created too. But I do want to see licenses that are not transferable, because we've seen the problem with alcohol licenses and taxi licenses.
Right, and you're right, there are a lot of things you can point to where that combination of limited license and transferability creates a problem. Now, we do know from our alcohol work that things happen, and if you had a license, for instance, that was owned by a husband, but the wife was working there with him every day, getting this business off the ground, and then the husband is walking across 6th Street and gets creamed, and dies suddenly. What happens with that license is an issue. So we've looked hard at transferability, and when I originally started talking about transferability, I just said it makes the most sense just to have no transferability. But it is a business, and there are investments, and so there are, I think, situations where we'll need to make the license limited transferability of licenses in certain situations. One thing that we're looking at is in Title IV, you can transfer both the ownership of a license and the location of a license. And that is something that's led over the years to the secondary market value, because you're just buying the license as an object and then plopping it down wherever you want your business. So one thing that we're considering and we're talking about, and again, that we're happy to talk to anybody about, is the concept of having limited transferability under these certain circumstances, but never being able to transfer the location of one of these licenses. So
That makes sense to us in local.
Right.
Because land use is the ability we have for control is where we put it at.
Right,
So
and
we
where it
appreciate
is, the
that.
value attaches where it is. So those are some of the issues we're looking at. And as I said, I was originally advocating for no transferability, but as we see situations come up every day with these liquor licenses, we see situations where we actually talk to each other and say, well, now what if this was a marijuana license and it couldn't be transferred? What would happen, to these business owners in this situation? Additionally, if you allow for corporate ownership, and then you've got some partner that, can no longer be there for one reason or another, you've got to recognize as a business tool that there's got to be some limited transferability. Certainly, the goal in marijuana regulation would be to avoid some of the more obvious problems that we have relating to what were the very lofty goals, I think very public safety oriented goals of limiting liquor licenses. And we certainly understand where that came from, and limiting the number of outlets does limit the availability of a dangerous substance. So we need to keep that in mind. But at the same time, babysitting someone's private value in their liquor license through continued board meetings over all kinds of things relating, to people wanting to sit on those licenses and hang on to them, or inviting anyone in a new industry to speculate by trying to get a license, not so that they can really operate it, but so that they can resell it. That is just something that we completely want to avoid. And it also, I think, limiting the transferability of those licenses, I think, will limit outside interests in these licenses. I mean, one of the things we hear
One last
over and over
question
again.
quickly, and I'll be out of the way.
Yeah,
Because this committee, lofty goals, look on the back here. Ernie keeps talking about all the things we told him to do, asked him to do. When do we think we're going to get the state regulations so this body can start to work on how they're applied locally? It's wrapped up with a lot of semi meetings to do crap, so they bring it to this stuff.
we're gonna meet the deadlines. We're gonna meet the
Okay.
deadlines. So
What
the
kind of
deadlines
deadline
are.
do you have?
So the deadlines are that by November 24th, the Marijuana Control Board would have approved the final set of regulations, and all the regulations would be approved by November 24th. Approval by the board means the next step is the lieutenant governor signs them, and that could take a day or a week or 2 weeks. And then once the lieutenant governor signs them, he gives them an effective date. And the effective date is 30 days out, always, for regulations. So the idea, the timelines and the initiative are that those regulations are effective by February 24th, 2016, 1 year out from the effective date of ballot measure 2. And that by that date, our board would begin accepting applications for licensing. And that the first licenses would then be issued in May of 2016. So,
Then you know what your job
Yeah.
is, Ernie?
Yep, nope, I knew the November 24th,
Yeah.
which is 30 days ahead of
Thank
our
you, ma'am.
date.
yes.
I'm just about.
Thank you, Cynthia.
Sure.
Always great information. And just listening to you speak, you hit a lot of the points that I was concerned about, because one of the first things that I tuned into was transferability. And just
Right.
like you said, it kind of creates a secondary market, and we're really struggling with that in the taxi industry, to be honest with you. It's something I would completely like to avoid, if at all possible.
We would too.
Yeah, and so knowing that that's on your mind, that gives me comfort. And the renewals, it's important to me that, we issue a license, but there's a mechanism, there's an opportunity that license comes back before us, just like we do conditional use permits. So we can evaluate if you have a bad operator, guess what, it's a privilege, not a right.
Right.
That's kind of where I'm at.
Right.
But the other thing it's been curious to me, I've had people say it to me, and I don't know a lot about fisheries, but I know I've been told in some aspects of licensing in Alaska, there are some components of it has to be Alaska owned, those types of things. I don't know a lot about it, but have you guys looked at some of the different permitting models for fisheries?
We have received a lot of suggestions to compare some of our rules to fishery rules, and we are looking around at all the sets of rules on all kinds of regulated industries to make sure that we don't miss some gem, that's out there. In terms of residency requirements, both of the other states that have recreational marijuana legal now do have residency requirements. They vary greatly from one another. What we don't want to do, because our staff is so small, is we don't want to create a requirement that then will create a whole new line of work for us to investigate. So we don't want to create our own residency requirement, which we then have to use staff time to determine if someone meets. We would rather point at a residency requirement that already exists in Alaska law. And of course, the one that springs to mind immediately is the permanent fund dividend, because people want to qualify for the permanent fund dividend. They have a motivation, if you will. If people are dishonest, they have a motivation to fudge their residency. We already have state employees investigating residency information for the PFD. So that would be sort of someone that would kind of do that piece of the job for us, if you will. If we just pointed at the permanent fund and said, you could only qualify to get any type of marijuana license if you also meet the residency requirements for the PFD. Not necessarily that you have to receive the PFD, but you have to meet the residency requirements for that. Now, anytime you make a requirement like that, you're immediately going to have people who say, well, there's all kinds of fights about that. Any requirement you come up with, theoretically you could end up having a fight about that. But that's something that we're willing to take on, as long as we don't create our own new residency requirement, which then requires Marijuana Control Board staff time to investigate, a person's yes or no, yes answer. And so I think that is something that you will definitely see and set 2 or 3. And we did look at other residency requirements, such as fishing licenses and those kind of things too. The only thing about those residency requirements is they don't tend to have that backup where anybody's actually checking behind the person's statement that they qualify, unless some special matter is brought to their attention. So we really, the other thing is that, Governor Walker has really encouraged us as a state agency to partner with our fellow departments and divisions. And revenue is one of the departments that we are partnering with on this marijuana effort, not only because 1738 contains tax provisions to tax marijuana at $50 an ounce at the cultivation level, but also because the revenue investigators share a mission in alcohol with us. We already work with them on alcohol establishments because there are alcohol taxes. So it's a natural partnership. And in March, our investigative division here in Anchorage moved in and co-located with the revenue investigators. So they actually work in the same office space in the Atwood building. And as we move forward, especially in this next year, as we attempt to shut down any place that's gotten out ahead of us and that's decided to open a marijuana business without a license and without being subject to regulations, and most importantly, without paying tax on the marijuana that they're delivering or selling, those revenue investigators are going to be our partners in making sure that we catch up with those people, we get those people to stop operating illegally, and then we get the marijuana taxed, and we get that tax revenue rolling in. And because any marijuana that is sold after February 24th of 2015 is supposed to be taxed. That's the law. And so if people are selling it and it's untaxed marijuana, we hope to catch up with them. We really hope to do that while at the same time that we're writing these regulations.
Sure. My last question, it's just more general. When you talk about sets 1, 2, and 3, can you give me a general idea of what you envision each set is going to contain?
We certainly know that because we're already working on set 2. We know that it's going to contain rules around each license type. So when you look at the definition of marijuana establishments in 1738, you see marijuana testing facilities, cultivation facilities, retail stores, and processing facilities. And those are the 4 types of marijuana establishments. We certainly see set 2 containing each of those types, containing more, fleshing those out and filling those in, if you will, in terms of what is what. And we're going to see, hopefully, all of the rules around testing facilities get up in set 2, because if there is any type of establishment that we want to license ahead of time, it's that testing facility piece. That has got to be in place before we have any licensed growers start growing. And so we're working very hard on the testing facility piece. It's certainly challenging given the geography of Alaska and the illegality of this substance at the federal level, the inability theoretically to put it on a plane, to have as part of your business model that you transport it by plane or ferry is going to be challenging for the testing. So we really looked hard at that and talked to a lot of people, spent a lot of time working on that piece so that we can get that up and kind of out of the way first. If there's any aspect of licensing, if there would be any exception to a residency requirement, it might be at that testing facility level, just so that we can be sure that we get the right investors in to get those testing facilities up.
That makes sense. And the third set would just kind of be a catch-all of whatever.
But there's going to be a lot left over, yes. And so that's why I say I would love to see local control in set 2 and all the rules around local control in set 2, but it is a big piece. It's a big piece of Title IV. It's a big piece of Colorado and to a lesser extent Washington. And I mean, Colorado certainly has a lot of local control and opt-out provisions built in to their regulatory scheme. So it may be that we don't see that until set 3. We really wanted to get this local option piece out first, so that if there were communities that were looking at opting out, that they could theoretically, if we can get this set through by a July or August meeting of the Marijuana Control Board, then those communities that are interested in doing that can begin working on that with their citizens.
Mr. Peterson has one more question I want to move on so we get to the rest of the agenda.
Thank you, Mr. Chairman. Cindy, I was just wondering if you've covered the licensing of medical marijuana and recreational marijuana being licensed separately or together, and discuss your reasons on that.
I will briefly, I could talk for an hour on this, but there's no medical marijuana in Alaska. There are medical card holders who can access marijuana the same way that everyone else in Alaska has been able to have the right for personal possession under the Raven Supreme Court case since 1975. So there's a big difference between Alaska and those other states when it comes to medical marijuana, because in other states, prior to a recreational marijuana, you could only get it by being a medical card holder. And I get it is the wrong term. You could only have it by virtue of being a medical card holder. So in Alaska since '75, we've been able to have a marijuana, just not get it, right? It's had to be this kind of magical marijuana. And the only thing being a card holder has enabled you to do that's different from what you or I could do as non-card holders is, number one, to have someone else grow your marijuana for you if you're too sick. And then number two, to have an affirmative defense to a possession charge in court. That's really the only two extra privileges that card gives you. It does not create something called medical marijuana. There is no such thing as medical marijuana in Alaska. There's marijuana. And we are not going to create two separate regulatory schemes for it. And we are not taking away, I've been accused of taking away people's medical marijuana rights. But 1737 has been on the books since 1998. And no one can show me in that statute where medical marijuana is created. Only an ability of certain people to use marijuana for medical purposes. But the big difference between Alaska and these other states is that everyone has had the right to possess marijuana in their own homes, medical need proven or not. And so, but that makes us different. And at this point, creating a separate medical category sends us into a morass of gray market, and it would undermine what we're trying to do here in creating a regulated market for substance.
One quick little question, promise. I'm not sure if the answer to the question will be. You talked about citizenship requirements to get a license. What about criminal record?
Well,
What are you guys going to do to ensure you don't have a criminal and trying to get a license?
so we had an addition to HB 123. That was an amendment that was added on the floor that prohibited anyone who had a felony conviction within the previous 5 years from being approved for a license. So that's a tougher, more restrictive requirement than we have in alcohol licensing, which gives us a 10-year look back, but gives the board the ability to grant someone a license even with a felony conviction under certain circumstances. So that's number one. Number two, we do want, when these applications begin coming in, to have an aspect of a financial background investigation. When we visited Washington, we visited with their licensing team, and they actually have 21 licensed investigators that are mainly looking at the financial background of the applicant to make sure that there's no drug cartels applying for those licenses. And so we have plans to do or to contract out for a financial background investigation as well. But no one with a felony conviction within the previous 5 years can
Would
qualify.
municipalities be able to make it even more restrictive?
I believe so. I believe that the way that the local control rules work now, generally, regarding alcohol, is that you do have the option to make things more restrictive. I would need to ask my lawyer that question, though, Mr. Trainee, because I don't want to say off the top of my head regarding a background, but regarding a criminal background.
Let's talk some more
Yeah.
offline on
Yeah.
this. Thank you. Thank you, Darren.
Mr. Moore, we brought you down because we know eventually we've got to enter into a discussion about local taxation, and you're the guy we talk to.
Okay. Well, we've had a limited amount of time to look into it and think about it. We do have some initial thoughts that I thought I could share today just to conceptually talk about it. For the Assembly, there's some important decisions in terms of what type of tax and whether it's a sort of excise tax like what the state's going to do or some form of a sales tax. And the sales tax could be at the wholesale level, it could be at the retail level. So that's an important issue because that determines whether it's it's done through a local vote or whether it's done through just an assembly vote. If it were, say, a retail sales tax, which would be similar to like what you all considered on alcohol not too long ago, that would have various potential benefits in terms of capturing, there's just a lot of complications depending on at what point you tax it. So retail sales tax is the very end of the road in terms of that. So it would simplify, we'd know who we're actually going to collect the tax from. That's important. We'd know where the source is, and you can control the rate in terms of not encouraging too much black market because that's, or personal grow, whatever. So if you were to do a retail sales tax, that would require a vote of the people. If you follow that alcohol model that was considered, you could theoretically do the 50% plus one. You could theoretically dedicate the proceeds to the cost of enforcement, which is actually kind of a big deal in other jurisdictions, and it'd be a big deal here. It brings in a whole bunch of additional needs, for zoning and the police and, health department, on and on and on. And so how are you going to pay for that within the tax cap? That's an issue. And so it's your all's call. But I mean, if you were to do a sales tax, you could present it to the voters. You could either have the 60% or the 50%, whatever your choice is. If you did the alcohol model, you also have to decide whether it's in or out of the tax cap. That's your call. But the main thing is whatever mechanism you use and whatever amount of money you hope to generate, you have to really associate with the cost of the program, all the costs of the program, just like with the alcohol issue. So I would suggest that probably OMB be involved and the different department, they can coordinate with the different departments and say, how much do you think the administration and enforcement of this new marijuana tax is going to cost the city of Anchorage? And then from that, you kind of know what level of tax you need to generate. In terms of a rough estimate, these are not giant dollars. We've looked at Washington, Portland, Colorado, particularly Denver. Denver is probably the best example that we have to go by. I'd say if you did like just a retail sales tax, you assumed about 50 entities sold retail. That's kind of a number we were working with. You're talking the low single-digit millions of dollars. Okay, that's if you say had it at a very low rate, like a 2% sales tax, retail sales tax. That would be considered very low compared to all these other states that have done this. Okay, if you wanted to go higher, and some of them have gone very, very high, you could go to 12% or 20%. I think it was in one of the jurisdictions, if you took the state and the local and the city, the county and the city all together, it was like 35% tax on top of, the price of the product. So, but that's where you have to be sensitive to people's alternative choices depending on how much you tax. And so it depends on what your goal is. If it's to make sure to cover all the costs of enforcement and everything, and that's basically a break even, that's fine. If there's some other objective, then you can adjust it accordingly. But there's a lot of decisions in terms of the structure that the Assembly will have to make. And from our look at it, I think there's two viable options that would make a lot of sense in terms of enforceability. One is the retail sales tax, and the other would be piggybacking on with the state. And just whatever they collect, we have our own rate and say, could you please collect an additional $10, $30 per ounce, whatever it is, and then pass that on to us, net of their own administrative fee. So those two are the most viable options just in the time that we've had to look at it so far. And other than that, there are other fees. There's fees and licenses, business licenses. Presumably the clerk's office would potentially get involved with the business license. There'd be various zoning fees. Different departments would potentially have, if we had a tax, Treasury typically would have a registration fee. And in these other jurisdictions, those fees they're significant. I mean, they're in the thousands of dollars. So, but then again, there's a bunch of state law legislation out there that's not yet approved. Some of them want to cap the control or the level at which you can add those fees. So I think probably working with the lobbyists, I don't know how much that was done last session, but I think we need to be really up to speed in terms of all the bills that are out there and how they affect local ability to determine limits. That's really important. So that's about as much as we've come up with. I mean, we can continue developing, but we're going to need a little bit more guidance in terms of which type of models or scenarios you'd like us to really, really delve into.
It's a great start.
Okay.
Mr. Trini?
Then excise tax. We use excise tax on tobacco.
Right, that would not work well for marijuana. And
Will it work well?
No, because it is not traceable and verifiable. Tobacco is heavily regulated at every single level. So we get manufacturers' reports literally from, the big guys, in Carolina and all. we get manufacturers' reports, we get reports from the state. We have a very concentrated number of distributors. We have the packaging, the stamping. Everything is there that we can really trace it and verify it. Marijuana, you don't know where it was actually, I mean, you could. I mean, I know they have certain things they try to control along the way, but I would not suggest going there. It's not equivalent to tobacco. I'd say it's much more analogous to alcohol. You know, that's what I would say. Even the potency, there's different rates with alcohol and potency. Same thing with marijuana. And if you do it at this retail level, the retail price will reflect the potency of the product. So it's just, I would definitely not try to follow the cigarette model. I just don't think it works very well.
Would you suggest that we have the state tax and then pass it on to us?
Yeah, that's certainly an option.
We do
Yeah.
that with.
We do that with auto
cars.
registration tax,
Yeah.
yeah. And that would be if the state agreed to that, and if you wanted to do that. If you do that, you give up control over the price level and the level of enforcement and some other special rules you want to put in place. You basically just give it, but it does simplify. We don't have to add staff, we don't have to have a new database, and some of these other costs that come with doing it yourself. It really depends on how much control you want in setting your own, own level, so.
Thank you, Mr. Chairman.
I've got about 12 minutes left here. I definitely want to hear from the police department lieutenant. Anything to share with us?
I have nothing for you today, sir.
You've
Unless you have
nothing for us
questions.
today. You're going to help me save time.
That's right.
Excellent. I appreciate that. Any questions? Yes.
I'll ask the lieutenant, did you have any enforcement issues with the convention that took place here a week or so ago?
Trade show.
Trade show, excuse me.
We did not have any issues, no.
I understand it went very well.
Yep.
Good.
Mr. Trainer.
Mr. Tabowski, you attended it.
I did.
What did you see going on?
For the most part, it was really, really well run. I thought it was, so one of the tagging mechanisms you're talking about, like tracing it from seed to whatnot, I thought that was fantastic. I talked to the tax attorney, who gave a lot of good information. And I did only see 3 people consuming there. One guy, I don't know what he was thinking. He was like standing a foot from me. Like, really? Come on. Because to me, when you have an event that's run so well, and you have a couple of morons that come in and do that, I think it tarnishes, the good operators. And unfortunately, I'll say that freely because he was standing like a foot from me inside the Denina Center. And then the other 2 that I saw out on the balcony. But for the most part, like I said, I wasn't there to babysit. I was literally there to learn, and I thought it was a good learning experience. But it goes without saying, when this industry gets up and going, it's going to be very beneficial for the industry to police itself. I think that's going to be crucial if you want to be successful. Because like I said, and fortunately, when I walked in within 20 seconds, I think, of walking in, everybody knew I was there. So I had I was greeted, and I had a great rapport with the security staff and stuff. And like I said, I thought it was a very well-run event.
Very good. Very good. Ms. McCall.
I have nothing to report either.
Very good. You're still plugging away over there.
Yes.
As we get more direction from the state, we get to phase 2 here. We'll have more to work with. And that works out very well because I want to make sure that we got a few minutes here for public comment.
Oh, can I go back to a couple questions?
You may.
I held them because I thought we were running out of time, but I'd like to go to it now. So Cynthia, if I can go back to you, I am not super familiar with the regulations and the state law and whatnot, but when we're talking about an industry now that might be transferring large quantities of marijuana, is that something that the board is looking at for regulatory requirements in transport of that? I'm thinking of, security, tagging, weight. I don't know what you would look at, but.
Right. So we definitely are looking at a traceability system. So I know Mr. Moore said that you couldn't trace it, or that we might not be able to trace it, but we must. I mean, we must know that the marijuana sold in retail stores was grown in a licensed facility, both so that we can make sure that it was taxed, and so that we can show the federal government that we're complying with the Cole Memo, and we have a strict regulatory scheme. And so we will have a traceability system. there are requirements that we will be writing around transport and security, and we have a lot of guidance from these other two states on that. We don't have as much guidance from Title IV because we don't have a lot of rules around transportation of alcohol, but there are a lot of things about alcohol that most people who aren't involved in the industry don't know. One of the things is that if you have alcohol on a shelf, for instance, that expires, because it is a product that expires, that there are specific regulations and rules around what the retailer has to do with that alcohol, who they return it to, and how it is disposed of. And those requirements are being met every day, sort of below people's radar. So we do anticipate a full suite of rules around all of those issues.
Well, and that brings up another point when you're talking about disposal of it. I mean, whose job is going to be to dispose of it? APD doesn't know, I think.
Well, I mean, APD's disposal of marijuana is related to marijuana that's confiscated or seized in relation to criminal charges or seizure, and this is different. So what most of the states are typically doing in terms of disposal of product is burning and controlled burns. And we met a retailer in Washington who had trouble. They use BioTrack, which is, I think, the seed-to-sell software system that was at the convention. And they were telling us about their experiences with BioTrack, and they said that they had entered a batch of marijuana products in their end of the system, and then it just disappeared, and so they really couldn't have that product at their store if the Liquor Control Board showed up, if it wasn't also tracked in the system. And so they did a burn of that product. They destroyed all of the product, and then 3 days later it showed back up in the system mysteriously. So they were kind of giving us their woes with BioTrack. And in the course of that, we learned that there is some disposal both by liquor control officials, and then there's disposal by the people in the business people themselves in terms of products. So another example was when we were touring Dixie Labs out in Colorado. That's an edible processing facility, and they're sending their products out, and they have to test out at less than 100 milligrams per package. And so they're sending a batch of products for testing. They found that they really had to adjust that downward so that in their own internal testing process, it was more like 90, because if they had something that came in just over 100, they would have to destroy that batch. So there's a lot of destruction that goes on just in the business processes themselves, and we'll write those rules around it.
My last question, I promise. And it's one that I don't see anybody here from the Department of Law, but it's a question that I've been concerned with.
You've got your municipal prosecutor in the room.
Do I? Oh, I didn't see Sorry.
You should be sitting up here.
I'm quite all right back there.
You can answer from back there. So my question is, last time I asked this question of the Department of Law, and I got a lot of blank stares, but it revolves around taxation. And until the federal government kind of deals with this issue, we're still we're collecting all this tax revenue, which in my opinion is complicated. I think is a good word to put it. So how do we, I mean, rather than putting the money in trust, I don't know what the state's gonna do, but how do you protect commingling this with other municipal assets until such time the statute of limitation expires, and then, you're okay to spend it? I mean, has anybody even talked about that? I don't know on the state level if they
You're
have.
gonna kick this one to me.
I sure am.
Christina. Well, in terms of taxation and commingling of funds and taxes collected from marijuana, we don't see any guidance there are 3 memos from the federal government that exist. There's the Ogden memo, the Cole memo, and then there's a more recent memorandum regarding banking the industry. And in all 3 of the memorandums, the federal government does not address tax money collected from regulated marijuana in states that either have medical or recreational or both as dirty money. So we don't have any indication that from the federal government, even though they have weighed in on issues relating to state regulation of marijuana, indicating that they would come after anyone for collecting those taxes. And we have to go by the guidance that they've given us. I mean, they have literally called it a grand experiment.
So they've
And
been silent on this issue, essentially.
by the fact that the memorandum does not say that we can't collect taxes, in fact, the Cole memo says we have to have a strict statutory and regulatory scheme at the state level. And of course, that's going to involve collecting taxes. So we're moving forward with the grand experiment. I mean, that's what the federal government has indicated that they have tacitly approved. And we have good company now. We're not the first, so that's a really good thing. It was really scary, I think, for Colorado to be the first. And I don't foresee this state getting caught up in, I mean, the Department of Revenue is here by our sides, you know, working on the taxation issues with us, so.
We're very short on time. Public comment. Yes, ma'am.
I have a quick question. You were talking about set 2 and putting in the opt-out clauses into set 2 so that the municipalities would have more time to opt out. But my concern with that is how can they opt out or decide to opt out if they don't even know what all the regulations are going to be yet? It seems a little bit backwards to me to maybe wait until all the regulations are out before they decide. But it would make more sense to give the companies who are setting up more time, like maybe put security or something like that. That's really important and will take a lot of time and effort and energy. Maybe put something like that into set 2 so that we have more time to set up. Just a suggestion, something to think about.
So just to be clear, opt-out is in set 1. Opt-out is
Okay.
already out. So
Okay.
these are the local option rules. And yes, I mean, it does, I mean, to someone looking at it from the industry perspective, it would make more sense for a local governing body to know what the rules are going to be before they decide whether to opt in or out. The opt-out rules are written for the long term. We have opt-out rules.
And I meant control, not opt out.
Yeah.
I meant control.
Local control.
Yeah.
Local control, maybe in set 3. It's a big piece. So we do expect in set 2 to see the types of licensing and also to see these fees that you mentioned, Mr. Moore. I mean, that's another thing that we're working on is getting those fees together. So what you should see in set 2 is more information about what it would look like to actually apply for and get one of these licenses.
Mr. Peterson, I want to take one more public.
And if the public wanted to review the regulations you've already written, what's the website for them to go to?
So that's the ABC Board website, and I don't have the URL memorized, but if you go to the alaska.gov and you go to the Department of Commerce, our website is listed right there among all the other agencies in the Department of Commerce. And when you pull it up, we now have it organized with the marijuana regulations right there on top. So you just go in there and you see the public notice and this set of regulations, that's set 1. And that's where all of those will be contained as we move through the process.
Thank you.
Yes, sir.
Ms. Franklin, you talked about the Cole memo. And I did take notes. Well, do you remember Cole memo or whatever memo it was?
The Cole memo is a memorandum that was written by an assistant U.S. attorney whose last name was Cole.
Okay.
And it was in 2013, I believe. And so the Cole memo was basically a priorities memo. It's not law, but it's a positions memorandum from the federal government that says it's not our priority to shut down businesses that are marijuana businesses in states that have legalized marijuana if those businesses are in compliance with strict state regulations. And then it outlines a priority list that would be federal prosecution priority. So basically, any sales of marijuana to minors, any sales of marijuana in connection with criminal operations. There is a whole list there in that memorandum, and I believe if you just Google the Cole memo, you're going to find it pretty easily. It's a pretty widely disseminated document.
So that is very, very important for us to understand.
Yes. It's important to understand that as we move forward with regulations, you know, we sort of have these these gates, right, or these bumpers, and we're gonna stay in those bumpers, and the Cole memo is one of those bumpers because it's what's gonna keep me from being prosecuted by the feds for
Okay.
working on this.
Very good, very good.
Yeah. It's very
Very good. Any other comments from board? Our next meeting is June 25th. We're going to continue to hold meetings at 4 in the afternoon. It's obvious we're getting a good turnout and participation in those. So we stand adjourned until June 25th. Thank you.